is Buadu TV. Truth and integrity.
NDC is contemplating introducing tribunals.
They said so. It's in their manifesto. Yes. Dominic Kayini said so at the
yes.
vetting. In the constitutional democracy of Ghana, the story is that President John Dramani Mahama has suspended the Chief Justice, Madam Gertrude Saki-Tokono. Every time we're on TV, then DSTV is gone off. Every time we're on TV, YouTube is gone off. Why? What is this? Why don't they want people to hear what we are saying? Somehow, Sanate George, I'll come after you. Don't bring yourself.
Etebusia kakra eyide tumno no ai ejana no odin Paul Adom Otchere se Samnate George aden NDC for musru good evening Ghana na onya sha se pe DSTV Metro na efiso YouTube kwen Samnate George Minister of Communication anya bia wonsa umbia na there be woni masem hu bia na I'll come after you obefaya wo wama kakra watija na kakra go so na wakasa dia fa aye AJ your friends the Chief Justice CJ petition see yi na fi ho ye suspend no sisi amampanya suspend no see yi na fi ho waban a brief history about enoma ekokọ so CJ sahodo aye nyane kwan a ye betimi afa so eyi Chief Justice say pesi eyi Chief Justice fi ho a sisi ase aka two arms of government no aka legislature and executive because sisi judiciary no yes sense omampanya suspend omo head no nti any head biem nti any Chief Justice until say the bo bi foforo din say wono enye acting kra no ye ni Chief Justice e wo Ghana na Paul Adom Otchere afaya de afasanse mo nyina ho afaya Mahama we hu amane pa.
His Excellency President John Dramani Mahama. This is Justice Gertrude Tokonu. The arrow swings from Tokonu to Justice Paul Bafuboni, a good man, whom I met the other day. I won't tell you where I met him. And the arrow goes to Justice Yoni Kulendi, and then the arrow goes to Justice X, and it goes to Justice Y. What are we depicting with this flyer? So bompaya eya kai Ghana Chre unyan kupon Fagana shenisa Enu na uyo main bapa Enu na uodo Odo ma umain Enu na yeshishe Odo ma umain Okay, let's look at the document that came, the letter that just came from the presidency today. Let's start with that and then we'll get on to I have a story on Iyoko that I want to talk about. I have a story on Iyoko, but let's look at the document. Okay, presidency communication. Do I have it this way? Yes. Tuesday, April 22nd, 2025, President Mahama suspends Chief Justice after setting up a committee to probe petitions. President John Dramani Mahama has, in accordance with Article 1466 of the Constitution, in consultation with the Council of State, determined that a prima facie case has been established in respect of 3 petitions against the Chief Justice, Her Ladyship Justice Gertrude Araba Isaba Saki-Tokono. The President has consequently established a committee in compliance with Article 1466 of the Constitution, in consultation with the Council of State, with the following composition to inquire into the petitions which have been referred to them. Justice Gabriel Scott Poamine, Justice of the Supreme Court. Justice Samuel Kwame Adibu Asiedu, Justice of the Supreme Court, member. Gabriel Poamine is chairman. Mr. Daniel Yao Domlevel, former Auditor General and member of Oral. What's happening? Former Daniel Domlevel, former Auditor General and member of Oral, is also a member of the committee. Military Major Flora Bazwanura Dalugo, member, Ghana Armed Forces. Professor James Sefa Jiza, Associate Professor, University of Ghana, member, pursuant to Article 146(10) of the Constitution, and in accordance with the advice of the Council of State, the President has, by a warrant, suspended the Chief Justice with immediate effect, pending the outcome of the committee's proceedings. These are the members of the panel. The committee. Today I've been talking to my producer. I say panel and he gets confused. He says, do you mean the committee? Yes, I mean the committee. So forgive me, viewers, if I interchange the panel with the committee, but it's committee. That's the correct nomenclature. Justice Gabriel Scott Poaman is a beautiful, nice man. But as we know, there's a petition that was forwarded to the president about the removal of Gabriel Scott Poaman from the Supreme Court. That petition, the president forwarded it to Gertrude Saki Tokonu, the Chief Justice. That petition is before the Chief Justice. So Poaman is going to sit on a petition about which a prima facie has been made against the Lord Chief Justice. Poaman was selected by President John Dramani Mahama to sit on the committee. Poaman has a petition against him right now. So we don't know. Do you know, viewers? I don't know. The lawyers, are you there? Please, can you send a text message to Good Evening Ghana Official? Let's look at it. Because Justice Gabriel Poaman has a petition pending against him for his removal from the Supreme Court. It's standing there. I have the petition. It's forwarded to the Lord Chief Justice, forwarded by President Mahama. So President Mahama, weeks ago, wrote to the Lord Chief Justice that, have a look at it, pursuant to Article 146, isn't it? That when there's a petition against a Supreme Court judge, you forward it to the Lord Chief Justice. President Mahama did that in fulfillment of his duties as president. Then President Mahama also nominates the same said judge about whom there is a petition against, which has been forwarded to the Chief Justice for a prima facie determination to be made, which the Chief Justice has forwarded to Gabriel Poaman for his responses, so that she will be able to make the prima facie decision. Now, we wake up this morning and Gabriel Poaman is chairing the committee that is going to listen to the petition against the Lord Chief Justice. I don't know. I'm not sure. I don't know. Then there's Justice Samuel Kwame Adibu Asiedu. Nice man, beautiful man. He's a great lecturer as well. I hear he teaches very well. Now, who is Justice Samuel Kwame Adibu Asiedu? Justice Kwame Adibu Asiedu, who is a member of this committee, is the same said judge who did not show up because he was unwell for the hearing of the matters that were raised in the writ of Asifwa relating to the injunction that was purportedly being prepared by the plaintiffs for the hearing of the court against the process of the Chief Justice's impeachment. So there was a legal action that was filed. You know, you saw the Attorney General in court, you saw Godfrey Dami in court, and Attorney General came and they said that the first day the Attorney General didn't come. So the case was not heard. It was rescheduled. It was rescheduled until last week, Wednesday. Last week, Wednesday, everybody went to court. All the media were there. We were told by the president of the court or by the lawyers that one judge, one of the 5 judges, is not able to sit. And so the case didn't happen. The said judge who was unable to sit is His Lordship, Mr. Justice Samuel Kwame Adibu Asiedu. He it was who couldn't sit, for which reason the application was not heard, and the application was rescheduled till May 6th. Now, in constituting the panel, President John Dramani Mahama nominates Justice Kwame Adibu Asiedu to sit. Some of the lawyers are telling me this evening that he may recuse himself because he's already on the panel. The panel will hear the matter on 6th of May. He has been asked to sit for the impeachment of the Chief Justice. There's a clear conflict of sorts. I don't know how you call it, whether it's conflict of interest, conflicts of philosophy, conflict of appointment. I don't know. But there's a kind of conflict of sorts, isn't there? There is. So Adibu Asiedu has been nominated by the president to sit on the committee, not the panel, the committee that is to look at the Chief Justice's situation to make a determination whether she should remain as Chief Justice or whether she should take a bow and get fired out and get disgraced. This Justice Kwame Adibu Asiedu, he didn't show up for the case. He was unwell. Now, he's nominated to I mean, to be on the committee that is to determine whether the Lord Chief Justice has done something wrong or not. Gabriel Pama has a petition pending. Maybe I'll give you the details of the petition. I don't know whether I'm able to do that. I'll consult the lawyers during the break. When I consult, they say I should show you. I will show you the petition. As for Daniel Domlevo, he's my man. You know, those of us who come from the south, Sogakopa, Jelukopa, Adudome, Keta, we are brothers. Those of us who come from the south, we are the same. So I don't know whether he's from Jelukopa or Sogakopa, but if you are Jelukopa, you are Sogakopa, you are Adudome, Denu, we are the same. So Domlevo is my brother, yeah. Daniel Yao Domelevo is on the panel. That's understandable. That's understandable. Auditor General, the matters that were raised about auditing, that's really understandable. That's understandable. And then we have armed forces people. I don't like talking about them publicly, so I will not mention the armed forces lady, the major. Major, I salute you. I salute you. Professor James Sefa Jiza. You may not know of her, but yes, she's on the panel as well. This is the matter that is going to occupy our attention tonight on Good Evening Ghana and many other nights to come. So bompaya eya kai Ghana shre unyankopon fagana shenensa. All right. Now let me tell you a story about Iyoko, and then I'll come back and Lawyer Bafo is here. Tonight we're going to deal with it big time. So since Kwabena Edubuahin was left to come home, we have been dealing with the matter. We have spoken to his lawyers in extenso, and we are getting to the bizarre conclusion that 1 + 1 is not 2. It's not always 2. Bizarre conclusion. That 3 + 3 is not 6. That 2 + 2 is not what? It's not 4. Do you know what happened? My friend Raymond Archer here, Raymond, you see his white beard, you know. His boss is this man here, Abdullahi Dapila, the Yoko boss. The Yoko boss is thinking, or we have been told that he's thinking, do we believe it? I don't know yet. That Raymond Archer here is marauding all over the place and doing his own things and setting his own agenda. And he's running on his own account. And he's able to convince President Mahama and Dominic Ayini that there was something wrong about what Kwabena Edubuahin's accounts or something like that. Viewers, as we speak, after keeping Kwabena Edubuahin and his dear wife in cells 3 weeks, the learned Attorney General, who held a maximum press conference and explained that he has already finished with Edubuahin and that Edubuahin there is in jail. 3 weeks after that, in the Republic and the Constitution, Edubuahin is yet to be charged. So today, what's the time? 9:44. Today is 22nd April. Kwabena Edubuahin is yet to be charged. Do you know why? Because they are beginning to find out that they may have been misled by the whims and caprices of Lord Archer. Why? Because the matters that were raised against Kwabena Edubuahin by Raymond Archer, which got everybody here excited, it's a very simple matter to have been investigated. Raymond Archer is not a member of National Security, has never been. Okay, he's a very good journalist. Never been a member of National Security. He says that he has found that Kwabena Edubuahin has an account, National Bureau account, and he has opened another account for his wife to buy things for national security. This is Raymond Archer's claim, which was repeated by Dominic Ayini, the learned Attorney General. Now, check this out, viewers. The matter that they are talking about, who should be the complainant? It should be the National Security Coordinator. He it is who can find the person who has replaced Kwabena Edubuahin at the National Signals Bureau and say, come, what is this account issue? If they find that there's a problem, they go to the National Security Coordinator. Between the National Signals Bureau and whoever is investigating, it goes to the National Security Coordinator. He will conduct an internal investigation and make a conclusion that yes, Kwabena Edubuahin moved $7 million United States from a bank into his personal account and nobody saw it. Kandapa, his boss didn't see it. President Akufo-Addo, Bank of Ghana, they didn't see it. Or the suggestion is that they were all part of it. So they all took their money and chopped. Okay. So Raymond Otchere managed to convince all these people. This man was suspicious. His boss was quite suspicious, but he was not part of the process. We are gathering all the information. They will wonder where we got it from. Don't worry. We are all Ghanaians. I told you that those of us who come from the south, Adudome, Sogakope, Zelukope, we are brothers. So I get the information. Now, he is worried that he wasn't part of the process because the process was handled lock, stock, and barrel by Raymond Otchere, the deputy Yoko boss. He handled the process lock, stock, and barrel. He did. And he sent the information to Dominic Aini, who swallowed it hook, line, and sinker. Dominic Aini then convinced President John Dramani Mahama, who is too busy. Of course, a new president is busy. He's handling 60 ministers, international community, Sahel problems. He's busy. So the president probably didn't look at it. He trusts the attorney general. But the attorney general is now finding out. You see, when you are eating fish bone and the thing chokes you, but the food is nice, but the thing has choked you. So, but the food is nice. So you still want to eat more food, something like that. The attorney general swallows hook, line, and sinker everything that Raymond Otchere did by so moto, as they say in law. So moto. He went around so moto that he has found something spectacular. And it's 3 weeks now, the attorney general, now the matter has shifted from law. Raymond Otchere is not a lawyer. The matter has shifted from gossip to law. You have to charge the person. In law, there are 2 words that I'd like you to go and search and tell me. A priori is Latin, and a posteriori is also Latin. Go and check. Raymond Otchere was operating on a priori. The matter has now come before the Attorney General. He has swallowed the evidence, hook, line, and sinker, the so-called evidence. Attorney General must now prosecute. 4 weeks, no charge. Because the charges are predictable. They are in the Criminal Offences Act, okay? They are already there. Act 29. 30 is the procedure. Now, he's going to look at it and say, should I pick stealing? So there's no charge called Kwabena Eduboyin has offended. No. You have to charge him defrauding by false pretenses, stealing, causing financial loss to the state. In each of these cases, there are ingredients of the offense. And you must demonstrate the ingredients of the offense. So the matter has now shifted from gossip, press conference, charade, and brouhaha. All that is fine. That is for us journalists. We jump about Yachino. No, that is not where we are now. The matter is before the Attorney General. It has to go to court. 4 weeks, Attorney General hasn't charged. So I'm suggesting to you viewers, at the beginning of our inquiry on this matter, we're going to come with a lot. At the beginning of our inquiry on this matter, first things we are finding is that Lord Otchere may have misled everyone on this Kwabena Eduboyin. He may have misled everyone. Was it a personal vendetta? Did he have something personal to prove? What was it about? So Bompaya, ya kai Ghana, Shrewu Nyankopon, Fagana Shenisa. No, now they are signaling me that I should stop the singing with my horrible voice and let's move on because we have a lot to deal with tonight. Tonight, we have so much. But I'm happy that I found time to deal with this preliminary matter. It's preliminary. We are going to go into it. Remember the things I said you should look for? A priori, a posteriori. When you see the meaning, send both to Raymond Otchere. That Paul Adom Otchere say you are doing something a priori, something a posteriori. What is it? This is what has happened. Now, viewers, causing financial loss to the state is an offense. It can be dealt with at any time. So Bompaya, ya kai Ghana. This is the matter. As for Yoko boss Abdullahi, he is unhappy. He may not admit it. He is completely unhappy. He thinks that Raymond Otchere is taking. He's a police officer. He's a COP. He knows what to do. As for National Security Coordinator, he is completely unhappy. That what is this? What are they doing? We hear, I told you, Zelukope, Sogakope, Adudome, Denu, we are brothers. I'll leave it here. I take a break. When I come back, we start with the ballot box. And then we go to Justice Gertrude Araba Esaba Tokonu. President John Dramani Mahama. Learned Attorney General Mr. Dominic Ayini. The Supreme Court's panel, 5 of them, seated to hear the matter, including Asiedu, who is now on the other side in terms of the committee that's going to hear the Chief Justice matter. Every time we're on TV, then DSTV is gone off. Every time we're on TV, YouTube is gone off. Why? What is this? Why don't they want people to hear what we are saying? Hey, they should stop that. Please, let me take a short break and tell everyone that I'm complaining that every time I'm on TV, DSTV is gone off. Somehow, Sanate George, I'll come after you. Don't bring yourself. What is that? Every time we're on TV, DSTV is gone off. YouTube is gone off. DSTV is gone. What is wrong with you people? You don't want people to hear what we are saying? Stop that. The person you are calling the book Adneza, did he turn off DSTV for people who are insulting him? We are teaching Ghanaians the history and you are afraid of the history. You are turning off the TV. What is that? This is the ballot box, okay? Please confirm with Apriko whether he has the photographs I'm looking for a moment. Please confirm with Apriko. Okay, so this is a ballot box, viewers. This is a very interesting and difficult matter. So as a country, or as any democracy, we have 3 arms of government: the judiciary, the executive, and the legislature. In the wisdom of the people who were discussing democracy in ancient Greece, and I refer to Cicero, Plato, Aristotle, and all of them. My favorite is Aristotle. The next favorite is Cicero. Now, in their wisdom, they decided that the ballot box should reflect the leadership of the executive and parliament. But the ballot box should not reflect leadership in the judiciary. Over many years of democracy, some people, even including some states in the United States, subject the ballot box to choices in the judiciary. So people run in New York to become Attorney General of New York by the ballot box. The Supreme Court in America is not elected. They don't do that. But in some of these federal arrangements, federal countries in the United States, Switzerland, Nigeria, and all of South Africa, and those federal places, some states have the state attorney general subjected to the ballot box. Okay. In Ghana, we don't, because we are a unitary state. We're a small country. So we go by the tenets of the Platonic prescriptions for democracy, or the Cicerorean prescriptions for democracy, or the Aristotelian prescriptions for democracy. All right. Now, in those prescriptions, the ballot box is for executive and judiciary, executive and legislature. The reason why they don't add judiciary in their wisdom is that there should be one organization that does not look at itself as partisan. They are appointed by the executive and confirmed by the legislature, both of whom are elected by the ballot box. But once they become Chief Justice, Supreme Court Judge, Court of Appeal Judge, High Court Judge, we call them the High Court, the Court of Appeal, and the Supreme Court. We call them the Superior Courts of Judicature. All right. So the ballot box here is to vote president and his ministers executive. Vote the president, he chooses his minister executive. Vote the parliament and they choose their speaker. All right. The reason why we do not subject judiciary to this is that when the populace have voted for legislature and for president and the work that they will do, the judiciary is there as a catalyst, as a bulwark, as a standing authority to protect the democracy. That is why, should I go from the start? Let me pick one. That is why in the year 2000, John Agyekum Kufuor was elected as president of Ghana by the ballot box. He was elected. Prepare Mr. Chikata's photograph. I'm coming there. Agyekum Kufuor was elected as president of Ghana. He and his party, the New Patriotic Party, won the parliament as well. They won it. And then, okay, I'll come to this in a minute. Let me finish with this one. And then, they won the parliament. Is that 2000? Yeah, 2000 is here. Okay. Yes, thank you. In the year 2000, NPP had 99, NDC had 92. I'll come to this 69. NPP won the presidency and won the legislature. But MPP did not win the judiciary because nobody wins the judiciary. So, right in front of J.A. Kufuor, the Supreme Court gave a verdict to Chachu Chikata. Mr. Chikata was being prosecuted under something called Fast Track High Court. Mr. Chikata had the confidence to go to the court because the court is not ballot. The court was not elected in December. The court was not elected in the second round. No. So he took his matter to the court that the people that you have elected, they are dealing with me the wrong way. And the court, by a Supreme Court majority, said no. There's nothing like fast track high courts in the manner that you are doing it. Let Chikata go. Haven't we seen it? We've seen it. Recently, 2020 elections, the verdict of the ballot went to the MPP by one, albeit. The verdict of the presidency went to Nana Addo Dankwa Akufo-Addo. Nana Addo Dankwa Akufo-Addo and his attorney general were prosecuting Kesela Tuforsen. The criminal process suggests that the attorney general will say his own, forgive my language. The defense counsel will say their own. Then the court will decide whether enough has been said for defense counsel to open their defense. When the matter was dealt with in the High Court, the High Court determined that Kesela Tuforsen has a case to answer because the Attorney General has made a point against him. Atuforsen, today the Finance Minister, he took his matter to the Court of Appeal. Why did Atuforsen have the confidence to take his matter to the Court of Appeal? Because the judiciary is not ballot box. They are not NDC. They are judiciary. The Court of Appeal, judges who were appointed by Akufo-Addo, they looked at the matter and said Kesela Atuforsen should go free. The High Court was wrong. Why didn't Atuforsen take his matter to the president? Because president is partisan. Why didn't Atuforsen take his matter to the parliament? Because parliament is partisan. But he went to the court. Kesela Atuforsen, he went to the court. Because the court is not ballot box. So you can go and speak to the judge. He's an independent thinker. He was appointed by Akufo-Addo means nothing. And Kesela Atuforsen is working today because the Court of Appeal under Akufo-Addo, judges appointed by Akufo-Addo, 3 judges appointed by Akufo-Addo, made a determination that Kesela Atuforsen is free. That is the essence of the judiciary and its opposite relationship with the ballot box. The crisis that we are suffering today is that it appears that the NDC, having won overwhelmingly in the parliament and overwhelmingly in the presidency, also want to transfer that victory to the judiciary. So they are uncomfortable with a judge who they cannot call and say, from victory unto victory, the NDC shall lead. The judge won't sing that song. Is it that the NDC is looking for a judge who will sing that song? So that the NDC has presidency, they have parliament, and then they also have judiciary. Everyone thought Akufo-Addo had judiciary. They said unanimous FC. Then Daniel Domlevo, one of the people who had a brutal fight with Akufo-Addo, and I stood here and made Akufo-Addo's point against Daniel Domlevo. But I'm not the court. As soon as the Supreme Court made a decision that Akufo-Addo was wrong in the removal of Daniel Domlevo, I shut up. I obeyed the court. I see Domlevo as Sugakope. I said, oh, bro, how are you doing? And he said, you. Yeah, I get it. You, I get it. But the Supreme Court has spoken. Today in Ghana, what we are being told is that the one who wins the presidency by the ballot, who also wins the judiciary, who also wins the parliament, must also win the judiciary. That is a disaster for democracy. Development is our goal indeed. Development is our goal. When I say development is our goal, I'm singing the NDC anthem. Stand up for Ghana, ye patriots of the land. Forward, seek your future. Development, our goal. From victory on... That's it. I don't know the NDC anthem. Okay, it's this. Arise, arise for Ghana, ye patriots of the land. Forward into a secure future. Forward into a secure future. Development our goal from victory. That's what they say. Development is indeed our goal. And this is what has happened. That the NDC has such an overwhelming majority. Now, okay, take me to the calendar. Take me to the calendar. Take me to the calendar. Yes. 1969. The Buzia MPP people won 105 seats out of 140. See how overwhelming. Calculate it. It's far more than 2/3. In 69. The MPP won the presidency by that huge margin because the election was only parliament. Prime Minister Buzia became the prime minister. He's one there. Thank you very much, producer. Prime Minister Buzia became the prime minister. Look at the overwhelming number. Please put the number again. Look at the overwhelming number. MPP won 105 over 140. Prime Minister Buzia and his government decided to sack civil servants. We have been here for long. He sacked civil servants, 69. One of the civil servants, his name is Salah. He went to court and said, why has the government dismissed me? The Supreme Court, by a majority of judges appointed by the military people who were MPP, they said that Buzia cannot sack 574 civil servants. Mr. Salah, nobody can sack you. The case celebrated among jurists is called Salah versus the Attorney General. Everybody in law school reads that case. That's why we all meet Mrs. Anijage. May she rest in peace. Fantastic woman. May she rest in peace. Philip Archer was in that. May he rest in peace. Akiomi was in that. May he rest in peace. This is what happened. The court held together. Come to 79. Please, come to 79. Because of time, I won't go to the details. 79. Give me the figures of 79. Liman had been elected as president of Ghana. Okay? The vote. Out of 140 with 4-5 parties, Liman's party had 71. They just crossed the line. So the PNP had the parliament, and of course the PNP had the presidency. And the PNP decided that they would change the Chief Justice. His name was Modesto Apalu. Modesto Apalu, one of the most distinguished judges we can ever have. You should hear Akufo-Addo talk about Modesto Apalu, you will clap. If Akufo-Addo is telling you who Modesto Apalu is, you will clap. You will enjoy the conversation, you will clap. Apalu was brilliant. The PNP felt that Apalu was UP. Apalu wasn't UP. He's a middle there. He's a middle. But he's scholarly. And I'm sure his friends were Buzia and Edward Akufo-Addo and all those. He had friends like that because he was very scholarly, okay? So the PNP came and said they would change Apalu. The Supreme Court said, no, you can't do that. You can win the presidency. You can win the parliament. But this Supreme Court is not political. It's law. It's legal. And we'll stand in the middle. That's why the scale of justice is here. It's here. Stands in the middle. The Supreme Court determined in 1979 that no way the government cannot remove Apalu. Apalu will be the Chief Justice. There's a way the government went about it. I don't have too much time. I can't say it, so I'll leave it. So you can research it. The case is entitled Tufuo versus the Attorney General. Last one. 1992. That one some of us can relate to. The NDC had 189 seats. This is Rawlings, the president of the time. Please give me back the figures. Let me show them. The NDC had 189 seats over 200. This is the biggest majority we've ever had in the world. You will not get a majority like that. 200 seats. National Democratic Congress, NDC, had 189. So they had more than 2/3, 95% of the parliament was theirs. And then J.J. Rawlings was elected as president. They had the presidency and they had the parliament. And then they came and said they want to celebrate 31st December because they are King Kong soldiers. They have come from 31st, whether you like it or not, whether constitution or not, they will celebrate. Peter Ala-Ajete. Oh, when I mention Peter, you have to bow. Great man. Peter Ajete took the matter to court. The Supreme Court, a lot of them appointed by Rawlings, said that, no, Mr. President, you can't do that. You cannot celebrate 31st December with taxpayers' money when we are under a constitution. Why? Because the scale of justice. So what am I saying? It is the Supreme Court that holds the balance between the partisan. Because as for politicians, I work with them all the time. I know how politicians think. They think one way. They think where they are going. They think their party. They think their victory. They think their development is our goal. That's all. That's what politicians, MPP, NDC, they're all like that. So we need the judiciary to hold the scales of balance. Now, again, the same Rawlings 92. The people said that rights to demonstrate cannot occur to a Ghanaian citizen. God bless Nana Akufo-Addo. Nana Akufo-Addo went to court and said, no, you can't say that. Look at the NDC's majority. 189 over 200. Akufo-Addo couldn't have gone to parliament. Nobody will listen. He can't talk to Rawlings about that. Rawlings will not listen. He went to the Supreme Court. The Supreme Court, by a unanimous decision, decided that Ghanaian citizens have a right to demonstrate. The case is entitled the MPP versus the IGP. Last one. Ghana Broadcasting Corporation, in the same 189 over 200. Ghana Broadcasting Corporation decided that they will not broadcast MPP things. MPP things, they won't broadcast it. Because Vincent Asise was there. And he was a big NDC man. So they said that GBC, you can't do it. God bless Nana Akufo-Addo again. Nana Akufo-Addo went to court and said, but how can the state broadcaster, who is funded by taxpayers' money, decide that they will broadcast only NDC things, they won't broadcast MPP things? What kind of thing is this? Akufo-Addo went to court, courageous. The Supreme Court, a lot of them appointed by Rawlings, decided that on the basis of the law and the provisions of the 1992 Constitution, the GBC is a public broadcaster and they must afford, this was the word, equal opportunity to all political parties. Equal, Justice Adom Otchere, God bless you, may he rest in peace. He was on the panel. Equal opportunity to all political parties. That's what the Supreme Court decided. Now, how do we have a president comes into power with an overwhelming majority and the agenda is that remove the Chief Justice because he's not singing our song? Did you have Mills there? I saw Mills. How is he doing? Prof, may you rest in peace. Now, Professor Mills, when he became president, enormous pressure was put on him that he should remove Georgina Wood, the law professor. He said, I cannot do that. I am a law professor. I have become president. And the agenda you guys are setting for me is that I should remove Georgina Wood as Chief Justice. I can't do it. Giddy, 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 butu, butu. President Mahama was the vice president. He knows what I'm talking about. He knows the extent of pressure that was mounted on Professor Mills to remove Georgina Wood as Chief Justice. Professor Mills said, me too, me nyadam da. Amen. Me figueo. Me nyadam. Or NDC people fought with Professor Mills. They fought with Professor Mills till the time that Professor Mills removed the Attorney General, Betty Moldidrisu. Is it not... What word should I use? Betty Moldidrisu is today a member of the Council of State. I sincerely hope that she abstained from this vote. I don't know the vote. I've heard people talk about it. But I sincerely hope that she abstained. Because she, of all, more than anyone else, must understand this situation. Because she was the Attorney General. I used to go to her office all the time to go and give her support when she was at Attorney General. Ask Elik Plim Agbamava. He was his PA. I'll call Elik Plim. Is Madam there? He said, Charlie, there's pressure on Madam. Would you have to come around 9 o'clock? I said, 9 o'clock, I have good evening, Ghana. I said, do you have it tomorrow? I said, no, tomorrow. They said, tomorrow, come. I was in Auntie Betty's office. And she would tell me that, look at what they are saying. And I'll be telling her, Madam, don't worry. You are doing your work. Da, 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 da. So I'm just hoping that Betty Moldidrisu on the Council of State remembers Professor Mills and remembers the pressure she went under as Attorney General. I gave her my full support in my little way because she was the first female Attorney General to be appointed. It was brilliant. And then she had to be removed. And it was sad. When she went to Ministry of Education, I would go there and go and see her. She's my mother. But today, Betty Mould is on the Council of State. I sincerely hope that she abstained. But this is the matter we are dealing with, viewers. This is the story. The president of, I saw it on BBC, Ghana president suspends Chief Justice. People were calling me from Zambia and say, hey, what happened? I say, take your time. Take your time. It's from victory unto victory. Development is our goal. So take your time. This is what has happened in Ghana today. The scales of justice has been turned like this. like that. And it's been turned upside down. Upside down. Adom Otchere, he's member of parliament for Tafo, is it?
Yes.
Okay. So he has amended, the matter is yet to be heard. We know that it was rescheduled for the 6th of May. He's amended the process. He says, the president has exhibited bad faith in the process of the removal of the Chief Justice. That's what he said. And we're asking why. He says, 1, the president initially exhibited an intention not to hear the CJ before the establishment of a prima facie case. This was further buttressed when the AG made the case that there is no law or case that mandated the president to give the Chief Justice a fair hearing before establishing a prima facie case against the Chief Justice. Now, this is the matter that's before the court right now. So, as you know, this is the matter I was talking about that the judge didn't sit, etc. The matter has been rescheduled for the 6th of May. That's when it will be heard. But the MP, the member of parliament, has amended his rate based on everything that is happening. He's asking the Supreme Court to consider these. That 1, the president of Ghana, John Dramani Mahama, initially exhibited an intention not to hear the Chief Justice before the establishment of a prima facie case. This was further buttressed when the Attorney General made the case, an Attorney General made the case in writing, that there is no law or case that mandates the president to hear the CJ. And many lawyers were concerned about that because one of the fundamental rules of procedure is all the alteram partem rule, which is to hear the other side. He thought that was very basic. But anyway, that's what the Attorney General said to court. The court is yet to hear these matters. So this is the amended rate. It says also that the president received the petition in February 2024 and waited till the end of March to disclose the receipt of the petition. All this was while he was undertaking consultations, which consultations were not exposed to the public. Okay, so they said the president got the thing in February, he kept it, suggesting that he had no intentions of giving it to the Chief Justice until the writ was filed and the Chief Justice wrote to him about it. All right. The other one is that the president, John Dramani Mahama, and his party faithful who occupy positions of power today, to wit, Mustafa Bande, who is the Deputy Operations Director at the Presidency, and Adom Otchere, who is a member of the Parliamentary Services Commission and the chairman of the party, have showed an intention to remove the Chief Justice already. So, in their writ, they detail some of these things like that. That Adom Otchere said this, Mustafa Bande said this, Felix Kwachu Fosu said this. We don't have too much time to go into that. I'm just suggesting to you that there has been amendment of the writ by Mr. Otchere, the Honorable Member of Parliament. At 20 minutes to 11, let's get on to the interview right now with Lawyer Balfour. Yes, Balfour, you said you wanted to start from Abraham Lincoln.
You see, Abraham Lincoln in his Gettysburg Address said something which I think is very useful for us to do. I'll read a part of it which I think is relevant. He says that it is rather for us to be here dedicated to the great task remaining before us, that from these honored dead, we take increased devotion to that cause for which they gave the last full measure of devotion. That we here highly resolve that these dead shall not have died in vain. That this nation under God shall have a new birth of freedom, and that government of the people, by the people, for the people shall not perish from the earth. You know, in 1992, when we committed to democracy, we did not commit to having the semblance of democracy. We committed to having a true democracy.
Okay, but let me ask you, what is wrong with what has happened? Article 146 says that if somebody wants to is unhappy with the Chief Justice, a Ghanaian, you can petition the president. When the president is petitioned, he consults the Council of State. Yes, he showed the letter to the Chief Justice. Council of State have looked at it. We are not seized with, I don't know whether you have the full petition, but Council of State has looked at it and they say that, hey, wait a minute, the Chief Justice has a question to answer.
Well, I'll tell you what is wrong with it.
Yeah, the president has the power then to suspend the Chief Justice.
Yes, cannot be isolated from a certain background. The background of Mr. Adom Otchere's statement, public statement on various radio stations.
Before the election.
Before the elections and even after the elections. As recently as last week or last 2 weeks. That they were fully committed to removing the Chief Justice. And that they will remove all the members or the leadership of the Electoral Commission. Mustafa Bande had also made a similar statement, if not the same. And so you cannot isolate that. these are the embodiment of the NDC.
That's the Mustafa Bande statement they put on the TV.
That's right.
Yeah.
The embodiment of the NDC. So it is difficult to look at what has happened as something which is in good faith. But I read the statement to remind us where we are coming from. You see, we've run into a situation where we want to politicize everything in this country. And the middle institution, the institution that finds itself in the middle, we want to also politicize it. But what most Ghanaians don't realize is that, as they say in Chi, is the grass that suffers. And so what we, the political actors, are doing now, right? Yes, we may be unhappy because we are guided by where we are coming from. But ultimately, who is going to suffer? Is the ordinary Ghanaian.
Why would ordinary Ghanaians suffer? If the government of the day have the Chief Justice they want, why is the ordinary Ghanaian
If you politicize the judiciary, there is going to be fear, right? A judge sitting on a matter between yourself and perhaps a friend of a big man, or a relative of a big man might be intimidated.
He'll be afraid.
Will be afraid, yes.
To pass justice.
To pass justice.
Because he'll be sacked.
Because, yes, he can be sacked.
Because the Chief Justice is looking at him upstairs. It's part of the umbrella.
Exactly.
Okay, that said, what is wrong with this process?
There's several things that are wrong. Let's first look at Article 146 of the Constitution. Article 1461 of the Constitution, which makes provision for the power, right, to initiate the removal processes, states that the president, the Chief Justice may be removed for stated misbehavior, incompetence, and infirmity of mind. What is stated misbehavior?
Something that has manifestly been done.
By what? What is it? What is the standard for determining stated misbehavior? There is no legal definition for stated misbehavior. Check. When you look at Ejechu versus Attorney General, it didn't define stated misbehavior.
But the petition was entertained.
Ejechu versus Attorney General considered whether, right, there was the need to determine, right, a prima facie case in the case of the Chief Justice.
Yes, correct.
It didn't consider Article 1461. So as we sit here, what constitutes stated misbehavior? What goes into stated misbehavior? We don't know.
How can we not know? Misbehavior.
Stated.
If I sit here and I take the water and I'm pouring it on myself, and it's not because Black Stars have won a game, I'm just doing that.
That's
stated misbehavior.
And so you can remove a Chief Justice because of that.
No, not because of this. I'm saying that the Chief Justice does. That's why the petitioner must allege what the Chief Justice has done.
Paul, you see, not every offense will amount to a stated misbehavior.
I agree with that.
Exactly. And so, if you look at the whole gamut of Article 146, I stated it the other time, the interpretation of it is still evolving. And so, Ejechu concentrated on the need for prima facie case, right? What do you call it? Dairy versus Attorney General also considered whether or not, right, the publication of aspects of the petition made it unconstitutional, right? And then went on to say obiter, that in fact the comments of the Chief Justice may be necessary prior to the determination of a prima facie case.
So what's wrong with what has happened?
What is wrong is that there is the need for a regulation, even if you look at Article 146.10.
Do you mean the suspension?
The suspension.
Or the prima facie, or
even
the process?
The whole process.
So what is the cure for a Chief Justice who is grossly misbehaving? What's the cure for it under the Constitution?
So the Constitution has made its provisions. To operationalize it, you need the regulations. And I will explain to you why you need the regulations. Paul, one, as I said, stated misbehavior is not defined. If you want to look at it even from the perspective of an employee-employer relationship, right? What may be considered misconduct is misconduct is omnibus. The elements of it are always defined. In this particular case, what goes into the consideration of a stated misbehavior?
Well, but audit reports, etc., etc. You can find. I mean, those things are there.
Yes.
So the judiciary is audited.
Yes. And so the Chief Justice, right? The Chief Justice goes into this whole proceedings, okay, wondering whether the offense or the accusation made against her will meet the threshold of stated misbehavior.
Yes.
That is what you do,
Yes,
right?
yes.
And that becomes, it becomes speculative.
Yes.
But the law is such that before you are tried for an offense, you should understand what offense you are tried and the ingredients of the offense, which is why even in criminal law, right, the offense, even when we say stealing, everybody knows stealing, yet
But
what
ingredients.
constitutes stealing is defined.
Have it properly defined.
You understand?
It's not every stealing in sociology is stealing in law.
Yes. So, Paul, now, fast forward from 146, right, 1 to 14610. That is the suspension. The provision of the Constitution says the president may.
May, yeah.
That is discretion.
Yes.
Look at Article 296 of the Constitution.
That regulates discretion.
That regulates the exercise of
Producer,
discretion.
can you put on 14610 and let's read it, and then let's put on 296 so people can understand what we're saying. So, can you put on the TV, please? Okay, great. So this 146, removal of Chief Justice of the Superior Court, removal of justices of the Superior Court of Judicature, Chairman, blah blah blah. Okay, so you're looking for 14610,
So,
isn't it?
yes, where
Where
a petition may be referred to a committee under this article, the president may. So the president then has the discretion. 296 regulates the exercise of discretion. Let's look at what 296
Please
says.
put on 296 if you can, and then we can look at it. So we are from 14610, which is about the suspension. The Constitution gives the president the power to suspend, but it says may. Okay, and so may clearly puts us in the arena of a discretionary authority.
Where in this Constitution or in any other law, discretionary power is vested in any person or authority. That discretionary power shall be deemed to imply a duty to be fair and candid. The exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment or. Let's go to C, and you see. Note that in all these instances, A, B, and C would say and. Please, let's go to C.
Yeah, to come to C. Please, can you give us C and then we look at it? They're taking long. Okay, but you tell us.
C. It says that it shall be regulated by by guidelines, right? Which may be a constitutional instrument or a legislative instrument, right? Now, Paul, do we have a regulation that governs the exercise of this discretion by the president? There's none in place.
No, is it a regulation for the purpose of 14610 or a regulation for the purpose of all discretionary authority?
No, the regulation for the purposes of 1461 and 14610. Because
Is 1461 a discretion?
the 1461 is a quasi-judicial function, right? And it makes provision for the grounds upon which the Chief Justice may be removed. Aspects of which requires definition, and that is my view, my position, that stated misbehavior has to be defined, and what constitutes stated misbehavior has to be stated, right? Now, when you go to 14610, okay, it is discretionary. And my argument is that there ought to be regulations to govern it. In this particular
You are
case,
saying that the Chief Justice should not be suspended. She should still remain Chief Justice. When there's a committee that's investigating allegations of wrongdoing against her, that's not tenable.
I'm saying that in the absence of a regulation, in accordance with Article 296C of the 1992 Constitution, the suspension of the Chief Justice, right, may potentially be unconstitutional. And my position is reinforced, firstly, because it's a quasi-judicial role which is being played by the President and the Council of State, right, by the case of Ransford France, where the Supreme Court actually stated that in quasi-judicial functions, a regulation is necessary.
Oh, I get your point. That is quasi-judicial.
It is a quasi-judicial function which is being performed.
So the president has a discretion, for instance, to name his ministers as many as he wants.
That is different.
That's different. That's not
That is not a
quasi-judicial.
That's not a quasi-judicial function.
So that discretion is regulated by what? Capriciousness and fairness.
That is not a discretionary power.
It's not.
No, the president has the power to appoint his ministers.
It's not discretionary.
It's not discretionary.
The number of ministers he appoints is discretionary.
It's discretionary.
Yeah.
But he doesn't need a regulation to govern that. But with the exercise of a quasi-judicial
Please give me the
function-
Constitution. Let me look at Article 78 and see whether this appointment of ministers has any...
Now, Paul, let me refer you to the case.
Take the camera off me. He wants to come and give me a book. He doesn't want people to see him.
Let me refer you to the case of Ransford, France.
Okay.
Where Dr. Ban stated as follows.
I'm listening.
He said, this court should follow the highly persuasive authority of Captain. The obligation to make regulations should be limited to discretion that are exercised in quasi-judicial situations. By that I mean where adjudication is involved. You know what a quasi-judicial situation is? The semblance of a court, where there is a semblance of a court. You understand? Now, the Chief Justice is going through disciplinary proceedings. Perhaps that would highlight the picture very well. Is going through disciplinary proceedings, which has led to her suspension.
Yes.
Now we sit here, we don't know the circumstance under which the president may suspend the Chief Justice. When the president of the Council of State determined that there is a prima facie case, right? Is it in all situations that the president may suspend the Chief Justice?
Once the Constitution says may, that means it's not on all
It is
situations.
not. So in what
it's at the discretion of the president.
So in what situation will he suspend? And in what situation
you
will he
mean we
not
must have
suspend?
predictability with that?
Yes, and
so
that is the
regulations must be
essence.
formulated by Parliament.
That is the essence of Article 296. And let me tell you.
That's interesting.
Let me tell you why. Let me tell you why it is even necessary. It is necessary because, Paul, the Chief Justice is not the President's Chief Justice. By the wording of Article 125 of the Constitution, the Chief Justice is the people's Chief Justice. And that is why when the President nominates the Chief Justice, he presents the Chief Justice to Parliament for approval. Because he takes the Chief Justice to Parliament and says to them that, I've nominated for the people a Chief Justice.
Is that the same for ministers? Because he takes ministers to Parliament as well.
The reason behind the ministers is different. If you look at 125 of the Constitution, it will tell you that justice emanates from the people.
Yes, correct.
And it is exercised for and on their behalf by the judiciary. And so the purpose for which the president takes the Chief Justice and other justices of the Supreme Court to Parliament for approval is not the same for the president, for ministers. For ministers, is because Parliament will be giving them, right, money to spend by way of budget. And so there's the need for oversight over them to determine whether there are people that can manage such funds and perform the duties of their office.
Fantastic.
That is different.
I get the point.
For the judiciary, they go there because...
Doesn't Parliament approve judiciary's budget?
They do.
Yeah.
But it is not brought by Parliament. It is brought...
It's not brought by the judiciary.
It is not brought by the judiciary. It is brought by the executive. That is the finance minister.
Okay.
So
they don't have any role. The judges don't have any role in you approving their money.
No.
Unlike the minister of, say, justice, who must come to the committee and justify it.
Exactly. But, you see, and so when the people have appointed their Chief Justice, you are removing him or her, right? And you think the people shouldn't have a say.
People being who?
The Republic, the citizens of Ghana,
through their
representatives,
who form the regulations,
who will pass the regulation
of how a Chief Justice can be suspended. In these circumstances. Okay, I have to say you're right, because I just looked at Article 78, and 78.1 says that ministers of state shall be appointed by the president, with the prior approval of Parliament from among members of Parliament or persons qualified to be elected as members of Parliament, except that the majority of ministers shall be appointed from among members of Parliament. Then it goes on. The president shall appoint such number of ministers of state as may be necessary for the efficient running of his government. So these are not discretionary.
Paul,
These are
you see,
obligatory.
what even makes the need for a regulation in this circumstance very, very necessary is that the whole system per the wording of the Constitution, Paul, is in camera.
Yes.
Indeed, even the Council of State, without the expression of the Constitution, would have done this in camera, because the Council of State's own business, nobody knows what goes on at the Council of State. True or false? Have you ever seen?
We've seen the president says with advice or the consultation. We
have never seen.
We are not privy to what they discuss.
Exactly. But more importantly, when the people have appointed their Chief Justice through their representatives in Parliament, they wake up to hear that the Chief Justice now has been suspended without an input from Parliament, which would have been done through the passage of a regulation
to regulate the exercise of discretion under 14610.
Exactly. And so potentially it is unconstitutional. And you say, when we are doing this, Paul, I know we are out of time, and I don't think that I don't need to belabor the point. Paul, the history of this country has been so politicized that, very respectfully, the Gen Z generation, they don't even know how we got here.
Because we don't tell our history.
Some of them,
they removed it from the schools.
Some of them think that this democracy, it just fell on our laps. I may be young, but by the grace of God, I've been around and I've read extensively. Paul, you'll not believe it. Even before I turned 15, I was using money given to me for lunch to buy newspapers. The newspaper vendor knew my house, and my mom will always be crying that they are making me starve. And at the time, I'd become very lanky as a result, because I used to starve and read newspapers. A lot of struggle have gone into this democracy, that we should not yield certain freedoms, right, and protections in the Constitution on the platter of gold. Paul, we have to be careful. We have to be careful. I think that Justice Tokonu owes our forefathers who fought for the 1992 Constitution a duty to fight for her office.
Fight for her office?
Yes. You see, when I refer to
the office doesn't belong to her.
No. Fight for her office, meaning that she's the occupant of that office today. That's what I mean, Paul. You see,
so she must bring an action to court.
She herself must mount the action.
In persona.
She shouldn't.
As a suspended Chief Justice.
Yes. Paul, let me say this.
To challenge the suspension.
Yes, she has to.
In the Supreme Court.
Because, Paul, you see, when you are bequeathed an inheritance, don't you fight for it?
You do.
And so when you have been given an office, knowing where we have come from, don't you think it should be fought for?
Well, I have some friends of hers say that she might not submit herself to the in-camera process. She wants a public hearing. Is that allowed under the Constitution?
Well, that would be a breach of the Constitution. But the last time a publication of the petition was done in the dairy matter, the Supreme Court even though said that, yes, it might have flouted the constitutional provision for an in-camera hearing, it still did not negate or invalidate the proceedings. And so it may well not be considered to be unconstitutional, dependent on how the Supreme Court looks at it. But Paul, you see, we all have a duty to fight to protect the Constitution. We don't have to politicize our judiciary, right? Paul, if we go
Somebody
on
will say that you were in town, not yet a member of parliament, when Akufo-Addo sacked Charlotte Osei.
Paul, Charlotte Osei is more or less, let me say, my friend, right? She fell on a sword by her own colleagues in office.
That therefore justifies the removal of Charlotte Osei?
No, she fell on that sword, right?
But they applied the constitutional processes to file an impeachment against her.
You cannot compare Charlotte's office as EC chair to that of the CJ.
Definitely, I agree with that.
We are referring to the head
You know, I was making a point. When all the political systems fall, from December 7th up until January 6th, and everything falls, the Chief Justice that remains.
Paul, do you remember?
When we go to the Independence Square for the inauguration, the only available leader in the country is the Lord Chief Justice.
That is why we need to begin to highlight the history of this country to all those who are on social media insulting some of us. It is not about Madam Gertrude Tokonu. It's not about her. It's about democracy. It's about constitution. Do you remember the case of Espati Shackelford?
I don't remember the details, but I remember the
title. By the late Crantinado, who was one of the judges that were killed, right? The martyrs of our democracy. At the time she determined Espati Shackelford, there was no constitution.
That's interesting.
There was no constitution.
So it comes out of natural law.
The courage of some of our judges, I wouldn't say all of them, Paul, anyone who has seen me in court, right, would say I should be the last person defending our judges. I've always had brushes with our judges. I've always. You cannot be.
You are proud of that?
Yes, you cannot be a strong litigator.
As a barrister, you are having brushes with judges?
You cannot be a litigator, right, very respectfully, worth your salt, if you cannot stand your grounds. And everybody.
Against the bench.
Of course. It happens every now and then. It happens every now and then. Look, you saw Thaddeus Sorry against Tokonu, Justice Tokonu.
Yeah.
Thaddeus by far is one of the best lawyers in this country. You cannot be a litigator worth your salt if you cannot stand your grounds against a judge. Very respectfully, we don't fight. It's just you standing your grounds intellectually.
But you're saying that this point is about institutions. It's not whether a judge is good, judge is bad. So you say once somebody has become Chief Justice, the person can do anything they want.
No, you can remove the Chief Justice.
But that's what they are doing.
Paul, what's she being removed for?
We don't know. Some petition.
You don't know?
Yeah.
What has she been suspended for?
Because a prima facie case has been found, and the law says that when a prima facie case has been found, the president may, in his discretion.
What went into the consideration of discretion?
That's why your point is valid. So there has to be predictability.
Exactly.
Because people don't know. Otherwise, somebody who doesn't like a Chief Justice
when you look at,
just gets a petition.
When you look at Article 296 of the Constitution, the only exception is for judges, right, and judicial officers. It doesn't include the Chief Justice. It doesn't include the president. And so somebody might say the president is exercising a discretion, is the president of the country. No, the president is regulated by the constitution of the land. And I am saying that we need to be careful. I am not fighting for Tokonu, Justice Tokonu. I am fighting for our constitution, especially against the backdrop of commentary that has been made by the chairman of the NDC and the General Secretary, Deputy General Secretary of the NDC. That clearly shows that this is a political witch hunt, right? So we need to make sure that this does not become the path we are going to travel henceforth as a nation. Tomorrow, if it becomes easy to remove a judge of the Supreme Court, the Chief Justice, it will become easier to remove a judge. When I have a case before the judge will be intimidated, especially because a government official is involved, a politician is involved, right? Already I have a problem with the mode of appointment of our judges, because itself, in and of itself, right, it creates a certain, discomfort among judges. Okay, now we are witnessing the removal of a Chief Justice. What is going to happen? When people are lobbying to become judges.
Of the Supreme Court.
The Supreme Court.
I know one.
Yes, when people are lobbying to become judges of the Supreme Court, what happens? They will be controlled. Or there's the propensity
That's
of control.
That's the point. They will be lobbying through political party apparatchiks.
Exactly.
Who have no basis to know whether they are good judges or they're not good judges.
Now,
so they're going to call Mustafa Bande and say, Mustafa, can you give my name to the old man?
Now, it is obvious that they can also be removed.
Oh, yes. In the same way that the Chief Justice, even the Chief Justice has been removed, how much more?
Yes. So where are we heading to? This is my concern.
Doesn't the NDC need control of the judiciary, don't they, to prosecute the reset agenda?
To do what?
The reset agenda.
If you think that there's a problem with the judiciary, pursue reforms. Luckily, you're undertaking constitutional reforms. Oh, all over the world, right, there's a revolution in terms of the appointment of judges. If that is what is giving you a discomfort. Now, Canada, for instance, right, has an independent body that appoints their judges of their Supreme Court.
We might need that.
England, the Supreme Court of England, now has an independent body that appoints their judges. And so if you have a problem with our Supreme Court judges and our Chief Justice, let's undertake a reform.
But once they undertake the reform, Justice Tokono will be there. They don't like her.
Paul, you are in power for 4 years.
8, maybe.
No, 4. President Mahama is in power for 4 years. Right? What at all can you do?
With what?
Look, even if you start criminal prosecution, right? Today, I can tell you may not finish within 3 years.
Was 7.
You may not finish within 3 years. What are you seeking to achieve?
Why do these cases take so long? That's a different matter. But anyway, let me not. The producer is putting this video together. Let me not bring in extraneous matters. Anyway, so your point you are making, Bafo, fundamentally is that the process, the way it has gone, is going to affect judicial confidence. It's going to intimidate the judiciary. And this is the most important institution for the protection of democracy.
Yes. You see, let me say.
The president has removed the IGP. He didn't say anything.
The IGP is literally part of the executive.
Oh, he is like a minister?
Of course, the IGP serves at the pleasure of the president.
Every day?
Paul.
Okay, that's why there was no impeachment process.
Of
Just
course.
sack him. But that's another point. That everyone the president wants to sack, he can sack.
Yeah.
When it comes to Chief Justice, a citizen,
the Chief Justice,
it must come from a citizen.
The Chief Justice is the head of an arm of government.
Like the Speaker of Parliament.
The Chief Justice, right, is at par, co-equal to the president.
Well, president is 1, vice president, under the constitution, president is 1, vice president is 2, speaker is 3, chief justice is 4.
But in terms of separation of powers, in terms of separation of powers, even though as a result of checks and balances, certain powers are exercised, or initiated by the president, okay, with parliament participating, okay, and then the judiciary too, for instance, the appointment of our judges. But it doesn't make the Chief Justice subservient to the president. So this is my concern.
I get it.
We have come too far for this to happen. Look, under President Rawlings, you rightly pointed out, there were several unfavorable decisions.
Made by the courts.
By the court.
By judges he appointed.
And President Rawlings, of all people, right, remember at some point, he even, out of anger, I've forgotten the exact words, attack the Supreme Court.
Yeah, on the 31st December case.
But he did not.
He said they want to obliterate 31st December from the history of Ghana and they will fail.
He didn't even contemplate the removal
of a judge or those judges.
You understand? I mean, what are we? Look, today, when you talked about the 31st case, do you know what dawned on me? You saw the position they took, that the celebration of the 31st with public funds may be unconstitutional. I'm sure that the real reason was to make sure that we forget about.
Absolutely, yes.
That might have been the real reason.
They wanted to erase that from the history.
Today, the NDC is contemplating introducing tribunals.
They said so. It's in their manifesto. Yes. Dominic Ayini said so at the vetting.
Yes. You understand? So we need to be careful.
Let's take our final text messages and see what people are saying, and then we can be wrapping it up. This is a very sad day in the constitutional democracy of Ghana. The story is that President John Dramani Mahama has suspended the Chief Justice, Madam Gertrude Saki-Tokono, from her job and has appointed her to a committee at the Council of State that's going to listen to a petition that has been written against her.